So thanks for coming along tonight on this cold night in Sydney, where Michael Kirby makes a welcome return to the Sydney Institute. He's a great friend of the Sydney Institute, and we very much value his contribution to what we do here. Now, as I said, everyone, we get to questions, discussion, everyone's got to be brief. It includes people on the Zoom, of which there are many. And I'll introduce Michael Kirby very briefly as the Honourable Michael Kirby, ACCMG, and of course a former Justice of the High Court of Australia, along with many other legal background that he has. But tonight, talking on a topic, suspect convictions and a criminal cases review commission. Michael Kirby, you're very welcome. Thank you.
Thank you very much, Gerard, and I would like to start, as has become customary in our country, by acknowledging the Indigenous people and the wrongs that have been done to them, including by the law. And it's about wrongs in the law that we are met together tonight to talk about how we can deal with wrongs and how we should put in place machinery and principles so that we can prevent wrongs from occurring in the first place. Fridays were a very busy day for me in the Court of Appeal when I was a judge of the Supreme Court of New South Wales, because Friday was the day on which I would tear myself away from the work of the court on civil cases and go into the Banco Court, or one of the big courtrooms in the courts in Sydney, and sit in criminal cases. I was normally presiding, and I therefore had normally the responsibility to make sure the case moved through its paces quickly, and that the judges in the appeal court were assigned to write decisions in the cases, so that would be their duty after the end of the oral argument. Most of the week I dressed in black, as I have tonight. But on Fridays, I dressed in bright crimson, which was the judge's robes for criminal cases. And even if I say so myself, we looked pretty magnificent there, sitting in our red robes, dealing with the cases. And the question that is lurking in the back of my mind is, were we magnificent? We looked magnificent, but looking and reality can sometimes be different. Now, in Australia in recent years, we've become much more conscious of miscarriages of justice. And this is a subject, actually, that I've written about on a number of cases and a number of occasions in law journals. And it's therefore one that I feel is within my competency, and I hope you will find it of value and interest. The cases on miscarriages of justice are not all big and famous cases. They are sometimes cases which are not known generally, though they tend to get known in the legal profession because it is always troubling to come to a conclusion that the way a case was decided in our legal system was less than perfect. The Folbig case of Mrs. Folbig, the Mallard case of Andrew Mallard in Western Australia, the Eastman case in Canberra, the Button case in Queensland. Now that was an interesting case where Mr. Button was convicted of rape. He always protested his innocence, and ultimately the matter got to the Court of Appeal of Queensland because by reason of his protests and support he gathered in the Council for Civil Liberties in Queensland, Mr. Button got somebody to go to the police headquarters where they kept the mattress that the offence was alleged to have occurred in. The mattress or piece of mattress was still there, which bore the semen of the alleged rape, which Mr. Button had always denied. And by reason of advances in DNA technology, somebody thought to put the mattress to a DNA test, and the DNA test came up negative to Mr. Button. Subsequently, the real offender was discovered. Mr. Button went to the Court of Appeal of Queensland, and Justice Williams, a very fine judge in Queensland, began his reasons for judgment. Today is a very bleak day for the situation of justice in Queensland, but we can correct it. And so after many years in prison, Mr. Button was exonerated, his appeal was allowed, his conviction was set aside, and he was set free. I don't know whether he got a bit of compensation. That often happens in these cases, but long years in prison are difficult to compensate. So these are the cases, and when you're sitting in a Court of Criminal Appeal, you have to decide the case amongst lots of other cases that you get on that day. This is not an ordinary job. This is a very responsible job, and the people who are engaged in the job, in my experience, are generally very serious about their duties. They have different approaches sometimes and different values, but our judges are not corrupted, and they are serious and they are professional about how they go about things. There were two cases in the recent collection that I participated in. One of them was the case of Mallard and the Queen. Mr. Mallard was a person suffering from bipolar disorder who lived in Western Australia, and he was charged with murdering a jeweller, Mrs. Lawrence, who was killed in her jewellery shop in a suburb of Perth. Mr. Mallard was interviewed by the police, and he was very happy to cooperate, and as is not uncommon apparently with people who suffer from bipolar disorder, he wanted to help the police. And so he went to a great deal of very detailed evidence about how, if he had been the person that did the crime, he would have gone about doing it. And that evidence was sufficient to persuade the police that this man was the offender. And so they carried the conversation on, they recorded it, and they charged him, and he was tried. He was represented in his trial, but he was convicted. He then came to the Court of Appeal of Western Australia and lost, and he then sought special leave to appeal to the High Court of Australia, and I was then a member of the High Court, where we just wore ordinary black robes. They're rather like Christian Brothers modern, designed at the request of Sir William Dean, who knew all about Christian Brothers outfits. But we Mr. Mallard drew a dream team, because the three justices of the High Court who heard his application for special leave to appeal were Justice Toohey, Justice McHugh and myself. We were three judges who, how will I put this, were sometimes inclined to be attentive to and supportive of appeals, and therefore Mr. Mallard advanced his case, but the barrister then appearing for him urged that the special leave should be granted because despite his request he was refused a lie detector in the trial in Perth. Now, in Australia, we don't have quite the same faith in lie detectors as they have in the United States, and therefore that was a hopeless argument, and it didn't make any progress, and Mr. Mallard lost his appeal, went back to prison, and he served 12 years in prison. But he had a supporter in the media in Western Australia. That reporter never gave up and kept urging Mr. Mallard's innocence. And ultimately the matter went back to the Court of Appeal of Western Australia, but that court refused to disturb the decision, and it then came back to the High Court of Australia. And I was there on a Sunday night, as usual, reading my special leave books, and there in the book I thought, I think I've sat in this case. I think I know about this case. And I then did something which is available. I looked up the Commonwealth Law Reports, and they have a list of the special leave applications, earlier special leave application, and they have a list of who sat in those special leave applications and what was the outcome. And so there I was, with Justice Toohey, Justice McHugh, and we refused special leave. So I called for the transcript and I sent a message to the registrar, please inform them that I sat in an earlier application. McHugh and Toohey had gone. I was the only one left. And I didn't feel I should sit in the matter, but what did they want to say about it? And they came back and said, oh, no, please do not go. We were very happy for you to sit. And so two very, very good barristers then appeared for Mr. Mallard. One was Mr. McCusker, who later became the Governor of Western Australia, and the other was Mr. Edelman, who had been an associate of Justice Toohey and who was later to be appointed a Justice of the High Court of Australia. He's sitting on the High Court now. And they were ruthless in their examination of the detail of the case. Detail is what really matters in most cases, especially criminal cases. And the problem with Mr. Mallard on the second occasion, he was granted special leave to appeal. The problem was that without the argument about the lie detector, they had an entirely different approach. They simply looked at objective evidence, and the objective evidence showed that Mr. Mallard was released from the Perth lockup at a certain time, and he then did a runner from a taxi at a certain time, and there was no time between those two times for him to get to the suburb in Perth where Mrs. Lawrence was killed. And therefore, objectively and incontestably, Mr. Mallard was not guilty. And he had served, I think, 12 years by reason of my order and the order of the other justices of the High Court refusing special leave to appeal. So his case was upheld, he was discharged, and I think he got quite a little bit of money from the government of Western Australia. But it showed that even a judge who was serious and conscientious, as I always was, can make a mistake. And why is that? Because you don't have time yourself to set up an entirely new hypothesis of the case and organise witnesses and get people to get the transcript and to follow new leads. You have to rely on the barristers to help you with that. And so Mr. Mallard won his appeal, but it left a really serious thought in my mind that I was a party in the injustice, and that is something that is disturbing to a human being. Now, the other case in which I was involved was Mrs. Folbig. Mrs. Folbig was tried in New South Wales for the murder of her children, and it was not one, not two, not three, but 4 of her children who had died. And the question was she guilty of murder? And her case was complicated by the fact that she kept a very detailed diary. And when, I think it was the 4th or maybe the 3rd child died, she rang her husband and said, "It's happened again." The question was there some innocent explanation? A woman would not ordinarily murder 3 or 4 children, but the statements in her diary were inculpating. They cast doubt on a hypothesis of innocence. And so when she came up to the High Court of Australia, the court was affected by the expert testimony on DNA that had been given at the trial, which said that the death of one child can be a tragedy, the death of 2 children could be coincidental, but by the time you get to 3 children or 4 children, it looks like murder. And so that was what the judges below in Mrs. Folbig's case had decided. But by the time she ultimately got to review of her case, she had new DNA evidence and evidence of genetics that appeared to indicate that with her particular DNA, the explanation that she offered could have been an innocent explanation. And that was ultimately accepted. It was accepted by the former Chief Justice of New South Wales in an inquiry. Mrs. Folbig was discharged after a very long period in prison, and then when I went back to look at who sat in Mrs. Folbig's case, I found there it was. I was one of those who sat in the case. The moral of the story is that our system of criminal justice is very serious and very painstaking, but it can make mistakes. Now, are these mistakes simply the inevitable mistakes of a human system with all the weaknesses of human beings? When I sat on Fridays in the Court of Criminal Appeal, it was a very difficult and hard day. There were generally, in my time, 2 appeals against conviction, very big appeal books, and 3 appeals against sentence, not so big appeal books. Written submissions of great length, argument of considerable length, trying to persuade you, and then at the end of the day, I had a consultation with my colleagues to assign, well, I'll do number 1, you do number 2, you do number 3, I'll do number 4, and number 5. The presiding judge had to do more than the others, all of this had to be done in the course of a week where you had so many other appeals, civil appeals, and this, I think, lies at the heart of the problem of our current arrangements, that the burden of getting through your chore of the cases that are listed for your hearing is intolerable and often crushing. And if you're conscientious, as most judges are, it takes up a great deal of time, energy and thought and you have to get the reasons out reasonably quickly, or you forget one case and it's swamped by learning of different cases. I'm talking to you now very personally and very truthfully about a matter that concerns a person with the responsibility of the judicial office, about the methodology of how we decide criminal appeals, and whether that methodology is not so compatible with the old principle that the common law would rather have 100 people who are guilty go free than one person who is innocent. Is that in truth what happens? Well, I would think in some cases it may be, but it isn't universally the truth. And this is why in recent literature, including in an excellent article that I wrote in the Criminal Law Journal, two questions have been raised as to whether we can improve the system whilst leaving it very much in the same state. One of those methods of improving things is to provide for a second right of appeal. And this is to cover the case where fresh and compelling evidence is later discovered, to permit a person to come back to the Court of Criminal Appeal and get on the path towards having the matter reconsidered by 3 judges. And in Australia, we haven't allowed in the past 2 appeals. You get one bite at the cherry and then you just have to serve your time. But in recent times, starting in South Australia, as many reforms in the law do, the change was adopted to permit a second appeal. That was copied in Tasmania, was copied then in South Australia, in Victoria, in Western Australia, but it hasn't been copied in New South Wales. And so the matter that concerned me when I'm writing the articles, what's so good about New South Wales that it's different from the other states where they permit you to come back if you have new and compelling evidence, which does arise, is available. So that's the first change that has been suggested. The second change is a change that was adopted in the United Kingdom in 1991. And that change was to establish a Criminal Cases Review Commission. And the Criminal Cases Review Commission is made up of 12 commissioners in Britain and a staff of 70, and they have the obligation of listening to submissions and arguments and investigating alleged cases of miscarriage of justice and looking freshly after a Court of Criminal Appeal has refused it. The change happened in England in 1991 because the passage of the 1970s and 80s had been of a large number of so-called Irish cases in which miscarriages of justice were undoubtedly demonstrated, which the courts had given the seal of good housekeeping. And that led to great disquiet about the system in Britain, and the answer to that was to establish a commission for suspect criminal appeals, Criminal Cases Review Commission. And the British reform was copied first of all in Scotland, the English reform in Scotland. It was then copied in New Zealand. It was then copied in Canada, but it hasn't, and although it's been urged in Australia by the Human Rights Commission, because of perceived defects in the current system, it hasn't been established in Australia. It hasn't been established in a single state of Australia. And so the question again is posed, what's so good about our experience in Australia that we don't think it's necessary to have a Criminal Cases Review Commission? Now, a Criminal Cases Review Commission has been successful in discovering cases of miscarriages of justice in about 3% of the cases that it hears. And that has led to convictions being sent back to the Court of Criminal Appeal with the report of the Criminal Cases Review Commission. So the final decision remains in the judicial branch, but they have the benefit of a commission which can include experts in DNA and other forensic skills that judges of their training and nature will not necessarily have. So that is what has been suggested and what has been done in Britain, in Scotland, in New Zealand, in Canada, but not in Australia. And so the question that is presented is, what is the reason for this reticence on Australia's part, on the part of lawyers and politicians in Australia? One reason is of tremendous faith in the jury, a very great belief in the mystical capacity of 12 citizens to decide matters correctly. Now, my brother David was a judge of trial in the Supreme Court of New South Wales. He sat in what I'll call wall-to-wall murder. He dealt with murder trials. Very hard work. You've got to keep every detail of the case in your mind. Much harder, I respectfully think, than being a justice of the High Court, because by the time you get it in the High Court, two very clever people, and sometimes more, have had it and had responsibility. But there's a great conviction of faith in the jury. And generally, my brother David says he only once in all the years he was a judge of trial did he disagree with a jury verdict. So that's a pretty strong statement about the faith that we can put in the jury system, but it's not perfect. And that is something that was demonstrated in the Pell case and so I believe in the Mallard case and in the Folbig case. So it's not perfect, but is it the best we can do for the money we've got? And should we simply say, well, nothing's perfect, we do as good as we can, this has lasted for hundreds of years, we should stick with what we've got and not worry too much about the possibility of miscarriage of justice. Well, that's all very well if you're not sitting in a prison cell complaining in your own mind, conversing with yourself and saying, why am I here? Why am I here for so long? Why will no one listen to me? Why will no one pay attention to my suggestion of innocence? And no one will secure the type of evidence that was found in the Button case and in other cases that led to the exoneration of people in earlier times. So that's why I've come along to talk to you tonight. It's a case spoken from the heart, from inside the boiler room, the very centre of the judicial branch of government, of very conscientious people, but of inherently difficult problems to be resolved, and resolved against the background of a system that puts great faith in the jury and great faith in the capacity of the jury relying on their perception of the conduct and behaviour and appearance of the accused person or of the witnesses against the accused person to result in the conviction that has such a lengthy and devastating effect on the lives of those who receive it. So that's it. That's what I came to say, and I've now said it. A big round of applause.
Many thanks to Michael Kirby for tonight. So we come to questions and discussion, and I'll be operating this third of the room here, and Anne the 2/3 down there, and we've got plenty of times and lots of hands up. So I'll just start off. So can I just ask you about the response to your Criminal Law Journal article? Quickly, fellow judges, are they happy with the concept of a Criminal Cases Review Commission? And secondly, would you have in mind something of a Commonwealth kind, or would it have to be one in the 6 states and the 2 territories? You'd have an individual commission?
Well, first of all, what would the judges say? Well, most of the judges are rather conservative, and most of them think this is something we've inherited for 1,000 years. The jury system in England really began as a result of the Catholic Church, because the Catholic Church in 1215, the year of the Magna Carta, issued an edict that trial by ordeal was no longer to be used in deciding a person as guilt or innocence. And after that, they had to find another way to determine, other than fisticuffs and battling it out on the field, and therefore they turned it to a jury, first of all to bring the evidence and decide the matter, and then to hear the evidence and decide the matter as best they could. So the judges, on the whole, I think, would think this is very expensive. A staff of 70 of the courts in England, and deciding in favour of the complainant about 30 times a year. That's a big investment of money in the Innocence Project. And it's really a question, not a question for the judges, it's a question for the community. The judges may say, well, our system is as good as we can give it, and it's been pretty good, and it's lasted 1,000 years. The judges are not corrupted, they do their best, and you just got to be satisfied with that and get over it. There will be some wrongful convictions, but life is hard, and their human justice is going to be imperfect. But as to how you could set up a Criminal Cases Review Commission, I think there are difficulties in making it a federal one for all the jurisdictions, because in Australia, like the United States, we did not make criminal law a national responsibility in our constitution. There may be ways that it could be done, and that would be much more economical and much more sensible for a country with our population. But there are some constitutional problems that would have to be solved before you could set up such a body as a federal, state and territory body. But there are people who urge that that should be done.
Put it up to him out.
Thank you, Your Honour. That was really informative. I just would like to ask 2 questions. One is, talking about the faith in the jury, do you think there's also an issue about having faith in the police and how they actually go about their investigation, and the fact that they have pressure on them to come up with results? That's one question. And the second...
Well, can I answer that first?
Yes,
Going
okay.
down the track
Okay.
from what the judges do are, of course, the investigators and the police. And most of the cases which have ended up going in the jurisdictions where they exist to courts, to Criminal Cases Review Commissions, and many of the cases involving a second appeal where that is permitted, are cases where the prosecution, i.e. often the police, have held back critical information, and they've become too convinced that the person is guilty, and therefore that they can modify the evidence and not give it all, not worry people about issues that may cast doubt on the testimony. So everybody is under scrutiny here, and the judges, the police, other investigators, and we ourselves as citizens are under scrutiny in how we handle this issue.
And the second, yes, I am very sick. And the second is, you know, the recent issue with the DNA bungle that happened in Queensland, where the DNA public service were not actually performing the DNA results correctly, where they've all had to go back and have a review. Do you think that would be persuasive to have the review commission show that it had a great necessity?
I think if we were to set up a criminal cases review commission, you would have to have independent advice to it on scientific evidence of DNA. It couldn't just be left to other bodies, because sometimes they will get it wrong, and that has been demonstrated on many occasions. For example, in the Chamberlain case, the so-called expert in DNA said that Mrs. Chamberlain had been guilty of killing her baby Azaria, and she identified what she said was fecal blood, but later explorations by commissions of inquiry and ultimately a royal commission indicated that that so-called blood was probably red paint from the inside of the car in which the Chamberlains had travelled and were holidaying in Central Australia. So you've got to be very careful, and also careful about the so-called giving of presents. If an investigator determined and believing that the person is guilty happens to give a present of a cigarette that is left at the scene, then that can be used against a person. And there's great faith in the DNA, but it's only as good as the steps that we've taken to preserve it and protect it and to ensure that it is genuine evidence in the matter.
Everyone's going to be brief, I guess.
Brief questions, brief
Sure,
answers.
and apologies in advance if this sounds ignorant, because I'm an American and I don't know a lot about New South Wales. So I wanted to ask, if you have the system in New South Wales that's different from some of these other states and territories, what is the mechanism or process to make such changes? And coming from the Commonwealth of Massachusetts, we have, our Supreme Court has the ability to affect certain rules itself, as opposed to going to the legislature for, you know, how courts operate. And I wanted to ask specifically, have you had any experiences like that for just changing the system of the judiciary?
Well, we have a very similar system to the American system. We don't have a general Bill of Rights, and that rather restricts what can be done by judges in deciding particular cases. But if they decide the case and they lay down a general principle, well, that if you're on the High Court, that'll run the whole length of this country. But our system is a parliamentary system. We don't have an elected president. We don't give so much power to an individual. We keep that under the control of the legislature and politicians in the legislature, and that has some disadvantages, but overwhelming advantages of getting things done. And so it would not. We got a change in the laws on abortion in Australia, not by the fiat of the highest court, but by the legislature. The parliaments of every state and every territory voted ultimately for change, and that's how we tend to do it in Australia.
Okay.
I hope that answers your question.
Got to be brief.
Yes. Thank you. Wonderful talk. Quickly, the Commission in the United Kingdom, 1991, what has been described as the worst miscarriage of justice in modern history in Britain, namely the post office scandal, was delayed. Justice was delayed for many people, suicides, imprisonment for decades or more. What could have been done to improve it? And secondly, is there a case for a scientific jury on both the Folbig and the Lindy Chamberlain cases? There was a lot of scientific muttering a long time ago.
Well, first of all, the post office case is a very terrible tragedy and a shocking instance, but it's recognised as such in the United Kingdom. Could it have been dealt with? Yes, it could, because there were convictions of all these humble post office workers of defrauding the state and pocketing the money. But this was all because of the misworking of a computer system which had been implemented by the government. It's a shocking case and a terrible case, and it affected thousands of people and thousands of convictions. So it's very serious. As to having a jury of people with DNA or forensic skill, I'm just as suspicious of that as I am of juries of only judges. I think you've got to be very careful you don't hand this over to the so-called experts, because in telling the truth or falsehood of testimony, you need multiple decision makers, and that of course is what a jury does. Not that juries decide all cases now. Some cases are judge alone trial, but generally serious cases in this country are dealt with by jury.
Okay. Better be brief.
Does the Commission in England has sent cases back to the court? How many of those court cases have then allowed convictions to be overturned?
Yes, it's about 2/3 are accepted, and 1/3 they've upheld the conviction, notwithstanding the report of the Criminal Cases Review Commission. So it doesn't entirely dispose of the matter, but that may be because the Commission itself says, I have supported sending the matter back to the Court of Criminal Appeal, even though I think the person was probably guilty. But I don't think they had a fair trial, or I don't think that the matter was properly handled, or that the judge directed himself or herself at the right questions. So...
No, we're moving on. Okay. There's a question here.
Getting back to the Appel case, I think it's generally considered the police investigation was completely incompetent. The first trial, there was no blame attached to that judge. What I cannot understand is how the Chief Justice and another got it so wrong as against the brilliant judgment of Justice Weinberg, which the High Court accepted.
The High Court determined that that was not a case that depended on DNA evidence. That was a case that depended upon the approach that had been taken by the trial judge and by the Court of Appeal of Victoria. I would like to give a little bit of respect to the majority, because thinking of the many cases which I sat in, where a criminal accused did not give evidence at the trial and relied on the obligation of the prosecution to prove the case, and had the prosecution produced witnesses who everybody agreed, or a witness who everybody agreed was a very convincing and truth-telling witness. But it took the analysis of the High Court unanimously to reach the conclusion that that wasn't a real answer to the complaint, that the trial judge misdirected himself and misdirected the jury on the basic flaw in the case from the point of view of the prosecution, which was that if, as the evidence said, Cardinal Pell, invariable practice, and the evidence of some people said practice on the particular days, was to go to the front of the church and say goodbye to everybody. I'm an Anglican, but that's done in most churches, and that is a normal thing. And that to get up to the sacristy and to have time to take aside a very heavy robe, it just didn't fit. And it's a bit like Mr. Mallard's case, with the evidence of the time that he was let out of the lockup and the time that he did a runner. This was evidence in the nature of objective evidence, and that led the High Court unanimously to say that it could not be said that Cardinal Pell was not an innocent person, and therefore that that is a miscarriage that has to be corrected, and it was corrected. So the system worked there, but not everybody's got the money to pay for a lawyer to take that to the top court and to pursue it at the lower levels, and it's a very expensive process. And it may be better to have some sort of executive or administrative fallback that will look at these things, but the Pell case did not turn on forensic evidence.
Thank you. Just about the concept of the commission, how would you suggest we advocate for something like that in New South Wales?
Well, you could suggest it by writing to the Attorney General. Mr. Daly is a person who might be open to this. It's surprising to me that Mr. Speakman, who was a very good Attorney General, excellent Attorney General, he's now the leader of the opposition, but he never thought that this was a matter that had a priority. It's a bit like when I was denied respect and travelling allowance for my partner. The Howard government said, this is not a priority. Sometimes there is a need for priorities, especially where matters of loss of dignity or loss of liberty. We've got to make sure we do respect issues and make it a priority. And the only way we can do that, we the people, is to do it by leaning on politicians who are looking at other priorities.
I have a question here from Richard Wilkinson on Zoom. How would the procedure of a commission vary from a court of appeal to make a difference in a case like Mallard's case, which you mentioned, where the council fails to find the best grounds for appeal in an application?
Well, it would have a multiple skill composition. A court of criminal appeal, by definition, is made up of judges and lawyers. And judges and lawyers tend to be people like me, who at school were very good with history, language, literature, not so good in mathematics, science and technology. And that's, I think, the answer, that you are calling different skills to bear on the decision where that is relevant to the particular case. I don't think it was relevant to the Pell case. And that's a sort of old-fashioned miscarriage of justice by applying an incorrect legal rule. But the real big issue now is the great number of cases that are determined by DNA evidence. That is terribly important, and it's very important that be got and placed before courts, and this is happening in growing numbers. But Chamberlain and Folbig demonstrate that it's not solved by just having the DNA evidence. You've got to have understanding of it and open-mindedness towards it, and not surrendering the obligation of justice to somebody who calls themselves an expert.
Your Honour, is it true that judges can be is it true that judges can be retrained? I understand the Australian Academy of Science and the Judicial Commission are in discussions about how to retrain judges after the Folbig case.
You've got to be a bit careful about the executive government retraining the judges. But it is true that nowadays there are systems for continuing judicial education, and that is something that didn't exist when I was first appointed judge in 1975, but it is now part of the role of a lawyer or a judge to continue to sharpen their knowledge and to be aware of new things, especially new technology. I mean, most judges nowadays use computers, and they do emails, and they even use mobile phones, and these new technologies are invading even the magnificent halls of the judiciary.
Your Honour, you referred in the cases that you dealt with as two factors. One, the competence of the argument put by counsel being persuasive and accurate, and the second one being the role of a interested media personality who kept up the fight. And that harks back to the Crew murders and the excellent book Beyond Reasonable Doubt by the English journalist that led eventually to the acquittal. So I just wonder in that case, and I myself in appeal cases have won appeals where the decision was that if the judge had been misled by the way it was argued by the counsels concerned in first instance. So that also happened, so that confirms. So my wonder is it the Judicial Commission so much, which could look at technical evidence and therefore DNA testing as such, rather than the decline in the media and journalistics, which harks back to a previous address which you attended, that will have a greater effect?
Yes, well, I also have hesitations about the idea that we pass everything over to the media, because they're very fickle friends of justice. Sometimes they will pick it up because it's sensational or there's something really peculiar about it, but often they don't have time. They don't have time or interest. You've got to have institutional arrangements that taps and uses people who have duties and obligations and are going to be people who worry about their cases and their outcomes and their decisions. But of course you are in the hands of the accused. In Mallard's case, Mr. Mallard clung to his view that he should have had a lie detector, but that was never going to run in Australia. But they were lucky to get Mr. McCusker and Mr. Edelman, now on the High Court, two very conscientious but also detailed. They worked on the detail of the case. And I sometimes asked myself, if you had had the time to look at the appeal books and go through every bit of the detail without the assistance of counsel, because they were pressing a different argument, would that have made the difference and kept Mr. Mallard out of prison for 12 years that he served? I don't think I would have had the time, and that's the truth of the matter. You have to rely upon the arguments that you get. You do your own research and you're sceptical about those arguments because they come from competence in the appeal court, but there's just a limit on what can be done. There's a limit that is fixed by the sleeping time, and by having time to sleep, have a meal, go home, sit with your partner, as I do, and as I will after this event, and just talk about the affairs of the day. Judges are human.
The question here, we're getting right to the end, just not on the Pell case but related to it, that when when that went up to leave of appeal, or whatever it was actually called, I think on that day, an Edelman sat on that, I think with Justice Gordon, on whether it got leave or not. There were 22 cases and one got up and 21 were rejected. So of the ones who are rejected, are they given the same kind of consideration as the one or more that's accepted? Because most applications for leave of appeal don't get up, do they?
No, they don't. The court could not survive if there was an unlimited right of appeal. It's just not enough manpower, person power. So to some extent, the personality of judges can also affect decision, their interest in the law, their concern for the risks of injustice. All of these features can matter. The two justices who granted special leave in the Pell case were Justice Michelle Gordon and Justice James Edelman. Michelle Gordon, an Anglican, and Justice Edelman, a Jew, and they upheld the appeal application of a cardinal to have his case heard, and then took part in the unanimous decision of the High Court upholding the appeal. It's a very interesting read, the decision in Pell and the Queen, and I'd commend it to you. It's more interesting than most judicial decisions.
Many thanks. Well, in conclusion, I just want to say we've had a very interesting night tonight, and an important one for a topic that Michael Kirby's been dealing with for a while, and today given a personal explanation of his own involvement in these kind of very difficult decisions. So it's not often that we get such an experienced former judge at the state and federal level come in and talking about real cases with a conviction about how reforms might be introduced in the future. So tonight, many thanks for coming back to us again, and we'd love to have you back sometime in the future.